All rise. You may be seated. Welcome back, ladies and gentlemen. Were there any problems in the overnight? Did anybody try to contact you about this case? So could you simply not resist the urge to discuss this case, or did you intentionally or inadvertently receive any information from the media, any type of source about this case? Very good. When we left off yesterday, the state had rested on rebuttal. It is now time for closing arguments. Ladies and gentlemen, closing arguments are not evidence. They are the arguments of counsel. You will hear from the state first and last. State of Ohio.
Good morning. This is the last opportunity I have to speak with you. And just right out of the gate, I want to thank you. And this is not just for myself and the other prosecutors and defense counsel, everybody in this room. I think I can, without being too presumptuous, speak on behalf of the DuBose and Tensing families. Somebody had to decide this case, and it took a lot for you to agree to do it, and especially with what happened last week, to continue to agree to do it. And whatever your verdict, we certainly appreciate it, and I want to thank you for that. Also, if there's anything, and again, I think I can speak for all of us, anything any of us did to offend you or you didn't think was proper, I don't think we did. This wasn't a, they talk about CSI isn't the way it is on TV. Neither are trials. A lot of times they portray trials as the attorneys one-upping each other and doing this and that, and it's just not the way it works. I mean, each other knows what the evidence is going to be that each side has. We let people know in advance what witnesses we're calling in a certain day, so everybody can be prepared to do the best job they can. So again, but if there's anything any of us did that you didn't like, you can hold it against us. Please don't hold it against our case. Count one is a charge of murder. What do we need to prove before all of you can sign a guilty verdict for murder? Judge Shanahan will tell you, and it's as follows. You will have to find that on July 19th, 2015, in Hamilton County, Ohio, that individual, Ray Tensing, purposely caused the death of Samuel DuBose. Well, let's go through those items. The first 3 points really aren't elements of the offense, but they're things that we need to prove in every case. First of all, the date, July 19th, 2015. There's no question that's when it happened. Sometimes the defense in a case is alibi. Somebody will say, I couldn't have done it because I wasn't even in town on that date. Well, that's not the case here, but one of the things we need to do is allege when this happened. Hamilton County, Ohio. You may have noticed we asked, I think, 3 different witnesses. Was this location in Hamilton County, Ohio? Well, the reason for that is the jury that hears the case has to be from the county where it took place. So if this crime would have taken place up in Batavia, for instance, a Claremont County would have heard the case. If it took place in Fairfield, it would have been a Butler County grand jury. But it took place in Cincinnati. That's why you citizens of Hamilton County are hearing the case. The third point is that it was Ray Tensing that did it. Most cases, that's really the key factor. Who did it? If there's a body found on the street and homicide comes to investigate it, they try to put together who is the person that did this. And again, that's not the case here. So those 3 things have been established, there's no question. But the actual elements of the offense, and even though it's one of the most serious offenses in Ohio, it's one of the least complicated. You need to find that the defendant purposely caused the death of Samuel DuBose. Those 3 points. Well, what does it mean to do something purposely under the law? Well, Judge Shanahan will define it for you. Basically, purposely means intentionally, not accidentally. There's a number of homicide charges you can have in Ohio. One is a reckless homicide, if you recklessly shoot someone. And every year in Ohio, there's a couple cases. In fact, the end of this month is deer season, where you'll have deer hunters out, and they're set up in their deer stand early in the morning, and they see some movement in the trees, and they fire their weapon without making sure they're actually targeting a deer, and people get killed. Well, they're reckless. Or sometimes people are playing with guns, and they don't check to see if they're loaded, and they point at each other. I had a case earlier this year, some kids were doing that. It's reckless. Other times there's negligent homicide. Somebody's cleaning their gun, and they do something wrong and it shoots. Well, that's not the case here, and the defendant never said that he accidentally pulled the trigger or recklessly pulled the trigger. He said, I intentionally pulled the trigger. And the definition you will hear is that purpose is a decision of the mind to do an act with a conscious intent to produce a specific result. The judge will also tell you, you may infer a purpose to cause the death of another when the natural or probable consequences of the defendant's act is to produce death in light of all the surrounding circumstances, including the weapon used and the ability to terminate life. And that's what we have here. The defendant was very clear when this happened. At the moment it happened, he pulled his firearm, he aimed at the only target he said he had, and pulled the trigger. And with that weapon, at 1 to 2 feet, only one thing can happen. He purposely causes death. Well, did he mean to do this ahead of time? It doesn't matter. There's a more serious crime in Ohio called aggravated murder. And if he was charged with aggravated murder, we would have to prove that he planned to do this. He certainly did not plan to do it, and that's why he's not charged with that. Not when he began a shift that day, not when he pulled Sam DuBose over. In fact, even when he's opening the car door, I don't believe he meant to do what he did. And we don't need to prove that he meant to do what he did ahead of time. All you need to find is that the moment he pulled the trigger, he did so intentionally, and if you so find, he's guilty of murder for that particular element. What else do we have to show? He purposely did it, that he caused the death. Well, it's obvious, but again, nothing is obvious in a criminal case, and that's why we call in the coroner. And her testimony was very clear. It was this bullet from that gun that caused the death. Now, the defense used the term a number of times. I wasn't really trying to kill him. I was trying to terminate the threat or stop the threat. Well, the coroner was clear. Her opinion wasn't that this bullet stopped the threat. It was that it caused the death of Samuel DuBose. So I don't know what the purpose of all that. In fact, a couple of the witnesses used that, and we asked them, was one of the ways to stop a threat, pull out a gun and shoot someone? Yes. So don't be confused by this language. He purposely fired the gun, which caused the death. He's guilty of murder. Judge Shanahan will also charge you on a second charge. You can consider voluntary manslaughter. And she will tell you, you only consider that if the 12 of you are not unanimously convinced that he's guilty of murder. If you find yourself at that point, then you go on to voluntary manslaughter. It's a much less serious offense. There's no need to show it was a purposeful killing. In fact, the elements are almost confusing. All the state really needs to prove for that is that he knowingly caused his death. But the judge will tell you that this case applies if you find that he shot in the heat of passion brought on by serious provocation by Mr. DuBose. It's really an option to prevent a miscarriage, but if you're not convinced, all 12 of you, that he's guilty of murder, but you don't believe he's totally innocent, that is an option for you. But again, you don't take an easy way out without, but if you really cannot agree on a verdict, that is something else for you to consider. And the defendant, in his statement, is really not contesting that he intentionally shot Mr. DuBose in his head and caused his death. That's not their defense. The defense is an affirmative defense. What do we mean by an affirmative defense? He has to prove it. We've proven the elements of murder. He purposely caused his death. And he's saying, okay, that may be the case, but I was justified. I had to do it. And again, that is something he has to prove by a preponderance of the evidence. And what that means is if you look at his defense that I had to do it, is there more evidence to support it or more evidence to not support it? And what is justifiable homicide in Ohio? Judge Shanahan, again, will read you a long definition, but basically it says a reasonable police officer under the circumstances he found himself in, who was in fear of great bodily harm or death, if he's in that situation, he can do it. So what's he telling you? He says, I was in reasonable fear for my life. Well, what do you base that on? That's subjective. That's what's going on in his mind. I was in reasonable fear for my life. Well, why? What was it? There's no weapon produced. There's no angry words. There's no reaching for anything. He says, well, I was being dragged. Now, being dragged is a factual matter. Now, if you find that he was being dragged, and as a result of that, that gives him a reasonable fear for his safety, then he's proven justification. If you find that he was not being dragged, then there is no reason for this fear he had, and that defense fails. So really, I believe the question for you is a factual determination. Was he being dragged when he fired the shot? Well, let's look at the evidence. What is the evidence? There's some physical evidence. There's some eyewitnesses. There's some experts. There's the body camera. And then we've got his statement. What about the physical evidence? Well, we've got his uniform. You've got pictures of it. You've got it. You've got all of it. All right, if you're being dragged, this is a question you ask yourself. If he was really being dragged like he said, look at that uniform. There's no question he fell on his back after this happened. I mean, it's clear from his body camera. Every witness saw that happen. The three other witnesses there when this happened, Miss Napier, Officer Kidd, and Officer Lindenschmidt. And I believe the evidence is pretty clear what happened. He ran along the car for a short distance, 10 feet, and stumbled and fell. And there is some dirt on his uniform. There's a couple little marks. But is there any indication of all that he was being dragged? None. Look at his boots. Even more telling. If you're being dragged, the one thing that definitely has to be in contact with the ground is your feet, your boots. There's a little tear in the back, and the homicide officers were smart enough to go through his uniform at the time to make sure what was and wasn't on his equipment before this happened, and the little tear in the back of his boots was there ahead of time. But look at his boots. And I would say particular attention to if he's on his side, like he said, the left boot. You probably have more scuffs and marks on your shoes than he had on his. So does that support him being dragged? His gun belt. He slammed against the car door. Well, okay, let's look at his belt. Let's send it to the lab. You know, we go with whatever they say. Microscopic examination comparing that gun belt to the car door. Sorry, nothing there. And finally, his body. I mean, if you're being dragged and finally he said, I skid along the ground for how much time, I don't know. What's he got? He's got, I think, a scratch on his arm, and what he says is some type of abrasion on his one knee. So that's one of the things you look at, the physical evidence. Does that support him being dragged, or does it say otherwise? It doesn't support it. And again, this is his burden to convince you. The second thing to look at, the eyewitnesses. His two brother officers, right there when this happened. Neither one saw him being dragged. Now they're saying, well, I was really out of position, and maybe they were. Maybe they really couldn't see. Or maybe they saw him fall straight back and they're just uncomfortable saying it. But you know, there's a third eyewitness, Alicia Napier, interviewed 6 hours after this happened, early morning hours. This young lady didn't have the benefit that Mr. Tensing had of seeing the body camera, and she's very clear in that interview what she saw. She sees the officer next to the car, she sees him going for his gun, she hears a shot, sees him fall backwards. Very clear that when that shot was fired, that car had not moved. Now she's saying as he's falling down, it's moving. There's nothing to contradict that. In fact, at the time, she believed the officer was shot. Is she shading her testimony in any way? How do you get past that? So again, the physical evidence, does it support him being dragged? Absolutely not. Do the eyewitnesses? Absolutely not. What about the experts? What about the coroner in the case? And this is, to me, one of the most preposterous parts of this defense. You know, when he's interviewed 2 days after this happened, the autopsy was not out. We don't have the results. Homicide doesn't have the results. Nobody's aware of this gunshot angle. He certainly isn't. And his testimony is basically, he's hanging on for dear life, basically back like this, looking through the window, and the only thing he can see is that head of Mr. DeBose. He pulls out his gun, and he's going to fire a shot. Boom, right there. What does he tell you he did? He didn't say in his statement to homicide on the 21st, but now he's telling you that when he's got that shot and he's in fear of his life and he's about to be killed, do you do this? Or do you do this? It's absurd. It makes no sense, but he's got to come away with a way to tell you why that gunshot angle went down. Is that believable at all? Again, he's got to prove he was dragged. And that's one thing he cannot get past. He's got to have a reason why this shot went down. Instead of what Mr. Fredericks told you, it's very clear. He's still at the window, and he's firing like this. And what about Mr. Fredericks? You know, in cross-examination, he was asked, for a time there, the body camera is pointing backward. Isn't that consistent with him being like this, and when the car moved forward, him being flung like this? And again, I'm no physics genius, anything else, trust me. But doesn't it make sense? This is just common sense. If you reach in a car and it's moving forward, aren't you going to be pulled like that? And he's saying that somehow his body twisted like this. Does that make any sense at all? And when Mr. Fredericks was asked, he said no. Actually, he said if the car went backwards, car's going like that, and your arm is pulled that way, you would be moved like this. But if it's going forward, no. You're going to be pulled to the left. They said, well, how do you explain the body camera for a short time pointing backwards? Well, again, he's the expert. He said it's real clear. He's by the side of the window, he's reaching in, and he's going for his gun. He said, this is just what his camera sees. I may still be looking at Mr. DeBose getting my gun out, but my camera is going backwards. He's the video expert. Nothing to refute that. And what else does he say in his opinion? To a scientific certainty. After everything he reviewed, 3 points. Number one, at the time this shot was fired, Mr. DeBose is in the car, and Mr. Tensing is standing outside the window upright. Number one. He's convinced of that. Nothing to refute that. Number two, at the time the shot was fired, the car had just begun to move no more than 2 feet. Nothing to refute that. And number three, Mr. Tensing was not dragged. So again, I ask you, do the experts support the defense that he has to prove? Absolutely not. The fourth thing, the body camera. And I don't care if you watch it in fast speed or in the slow motion speed, does that support him being dragged? It absolutely destroys it. And if you can't read this from there, I apologize, but basically, if you go through Mr. Frederick's report, there are some key times in his report, and he's got it marked on the screen, and the key number is how many seconds until the shot takes place. At the one point, you see Mr. Tenzing's hand on the roof of the car, and it's leaving as it's starting to go into the car. 2.4 seconds until the shot is fired. Nothing has happened at that point. You keep progressing at 2.13 seconds, and you can look at yourself, and I think even later you could probably say his hand is not in contact with anything, but clearly 2.1 seconds to go. His right hand is now not visible. His left hand is in the car, in front of the steering wheel, not touching anything. At that point, he's clearly not being dragged. At 1.22 seconds, less than 1 second later, you can see the gun in the screen. And I'm just looking at the parameters. And what does he say happened in less than 1 second? In less than 1 second, he tells you his hand is hung up in the car. First that happens. And then the car starts to pull him down. And then he sees himself falling down. And then he feels himself being dragged. And then he's thinking, my God, I'm going to get killed. Then he has to go for his holster. And you'll have it back into the jury room. Normally we put a clip in the weapon so it's rendered inoperable, but in the event you want to just see yourself, please don't load the gun until jury's happened. Test yourself. Again, in less than 1 second, all this is happening. His hand is stuck, pulled down, on the ground, feet on the ground, he's lost his footing, he's being dragged, he's going to be sucked under, and even at that awkward position, he's able to do the double manipulation of the holster and get the gun up. In less than 1 second. It's impossible. It is physically impossible. But that's what he says happened. In fact, there's no question, from the time his right hand leaves the roof until the gun appears, the second his hand left that roof and his other hand is going in, he's got to be already going for his gun because he's able to draw it and bring it up in a little over a second. Again, that is the body camera. You cannot say anything to change what is on that image. Grant Fredericks, and he's very conservative on what he says. He keeps going to that car in the background. I'm the car in the background, here's the window. If the car is starting to move, your perspective is different. He says the last time I can say for certain is at 1.059 seconds. I can still tell you, and this is what I do for a living. I teach FBI agents how to do this. That car had not moved. He says sometime in the next half second or so, 3/4 of a second, it started to, but he said at that point, Mr. DuBose, his hand has come up and his head is going back, and I don't have the view I need to tell you when it actually did begin to move. But the first time the car is definitely in motion, and again, this is, I don't know how many times I looked at the video, and he talks about that air freshener movement. I mean, maybe you would have noticed that. I've looked at these things, I don't know how many times, I would have never noticed it. But he can say, at that point, I believe the car was in motion. So again, this is another piece of evidence you look at to decide, does it support what he has to prove? Absolutely not. So what are we left with? We're left with his statement. What about his statement? He had 2 days to decompress, to think about it, to consult with an attorney. I don't know what else who else he spoke with, what else he did in those 2 days, but he's got 2 days to get his story straight. He has had the opportunity to view the body camera video. And what about in his statement? He was very detailed. He was very certain. He didn't hesitate at all. And now that he looks at all this other evidence, he realizes, you know what? It doesn't add up. So what's he using now for the first time in this trial? A word that never appeared once in his interview, but a word that has appeared over and over and over in his testimony. Well, that was my perception. What do we mean by that? Again, he has to factually prove he was being dragged. And now he's saying, well, that was my perception. He's basically acknowledging, I can't prove it. There is no evidence of it. Again, he was very certain in his interview what happened. Now, he's not. In closing, there's two things this case is not about. And this was a big part of your questionnaire, and it's a big part of the voir dire process. This isn't about being pro-police or anti-police. It's not about pro-Black Lives Matter or anti-Black Lives Matter. This is about what this officer did on this date under these circumstances. This officer, this date, under these circumstances. And one of the most significant things that came out in this trial, it was very early on in the trial, you've got two other police officers there that are aware of this stop. No front license plate, slow to stop, they pull up, they're going to walk out and back up, and all of a sudden they see their officer. Officer Kidd actually saw Tenzing lunge into the car. They both hear the shot. What's the first thing they asked him when they got to the top of the street? Officer Kidd, did he have a gun? Officer Lindenschmidt, twice, did he pull on you? Because under these circumstances, again, these are his fellow officers facing the same set of circumstances from a distance. That's their assumption. It's their instinctive reaction. He must have had a gun. He must have pulled on you for you to do what he did. Well, no, I got tangled up in the car. You know, we have, unfortunately, hundreds of police officers here across the United States are confronted with situations where they have to shoot someone. And in 99% of them, the person they shoot is either coming at the officer with a knife or with a gun or what appears to be a gun, or when they're told to show me your hands, they're going like this, or they're reaching under the seat. And that's why 99% of the time, when a police officer shoots someone, it's justified. And had Mr. DuBose reached for a gun or come at Tenzing with a knife or done anything to indicate he was a threat, this would be justified. All he did was, for whatever reason, shut the door and started to turn on the key. And for that, he was shot in the head and killed. And something else this isn't about is Mr. DuBose. Defense through great lengths, 4 different witnesses, they asked about the marijuana in the car. What's that got to do with anything? And maybe they'll say, well, it's why he wanted to get away, because he had this money and these drugs. Was he a weed dealer? I think so, based on this evidence. They put him on trial. And if this was a trial against him for being a weed dealer, I'd say guilty. He's got money. He's got drugs. Does that mean it's okay to shoot him in the head and kill him? Even if he knew it, even if Tenzing knew he's a low-level marijuana dealer, does that mean, oh, okay, we found out now that he sold marijuana. It's okay. It's all right that you shot him. No. But he didn't know any of that. What's that got to do? You know, this defense is about his state of mind. Tenzing. Did he see any drugs in the car? No. Did he smell any drugs? No. Did he think Mr. DuBose was under the influence of alcohol or drugs? No. Did he see any weapon or make a move towards you? No. So why did we hear on cross from 4 different witnesses, well, did he have marijuana in the car? What's the relevance of that? And that's why I tell you it's not. It has nothing to do with anything. All he knew about Mr. DuBose was he was driving a car without a front plate whose owner, who was a female, was under suspension. That's all he knew. For all he knew, he could have been you or me or your brother or your dad or your son. And what if it was? under these circumstances? Would you think it was justified? Would you think he was only doing his job? Would you think he had no other option than to shoot your brother or your son or your dad in the head? No. You'd feel the same way the DuBose family feels. And that's why I ask you, the one thing they asked of us is what I'll ask of you is for justice.
Mr. Piedmeier, Mr. Matthews.
Thank you, Your Honor. May it please the court.
Mr. Gibson, Mr. Dieters, Mr. Piedmeier, ladies and gentlemen, as Judge Shanahan indicated to you, this is our final opportunity to address each of you about what we think the evidence in this case has shown or has not shown. On behalf of the defendant, I have this one opportunity to speak with you. Mr. Piedmeier just had the prosecution's first opportunity. Mr. Dieters or somebody will have an opportunity to address you once more after I conclude. Judge Shanahan will tell you in her instructions that just as with our opening statements, what we say in closing argument is not the evidence. And it's just simply our interpretation of what has happened or has not happened in this courtroom. The evidence is what the testimony you heard from the witness stand and all these exhibits that you'll have with you back in the jury room. You, as a collective body and individually, are charged with remembering what the evidence is and deciding the outcome of this case based on the evidence, not on what the lawyers say. And I throw that out there because I've just heard Mr. Piedmeier's very eloquent opening portion of his closing argument, and while there's one or two things in there I can agree with, most of what he said I do not agree with, and I don't think the evidence supports most of what he just said. You know, he told you that this case is about what happened in this courtroom. And you'll remember on voir dire examination, I asked each of you if you would be willing to decide this case solely upon what happens in the courtroom. It's what happened between Sam DuBose and Ray Tenzing, and the color of a person's skin has nothing to do with it. Mr. Piedmeier just indicated it's not about Black Lives Matter, and it's not about police versus citizens. I can't remember exactly what he said. There's one other thing that this case is not about, and I would ask you all to keep this in mind. It has nothing to do with race. This is an issue that I am going to address for a couple minutes because I don't know whether it affected any of you, but the other day there was an image displayed on this screen of the undershirt that Ray Tenzing had on July 19th, 2015. That undershirt was a black t-shirt that said Great Smoky Mountains, Tennessee, and it had a Confederate flag. Now, presumably you all, and I'm sure you all have stayed away from the news media, but when that came up the other day, that just blew up on the local news media. A big deal was made out of it, and it continues to be made. And I don't know of any reason in the world why that t-shirt that Ray Tenzing was wearing that day has any relevancy or probative value or anything to do with this case. You'll recall that I asked several police officers before that t-shirt was ever produced, what is the uniform policy at the University of Cincinnati? And they told you that the University of Cincinnati provides uniforms to their officers. There's a summer shirt that's open, top buttons are open, and they are required to wear a black t-shirt under that shirt. You all probably thought, what in the world, where is he going with this when I asked those officers that? But where I was going with it was I knew that t-shirt had been taken by Police Officer Odom at University Hospital from Mr. Tenzing, and I figured these guys were going to throw that in here for whatever reason. And I'll tell you what I think the reason is here in a minute. But you heard Officer Tenzing testify yesterday. That t-shirt was given to me by a relative. It had absolutely no significance to me other than the fact that it was in my laundry bag. I picked it out that day, and it had black up here where I was required to show black under my uniform shirt. The writing on the shirt, the flag on the shirt has absolutely no meaning to me. And I would submit to you, ladies and gentlemen, that t-shirt, again, has no evidentiary value. You'll recall that Officer Odom when he took the clothing from Mr. Tenzing, he took his carrier vest, that was the outer vest, which you'll have back in the jury room, that has marks on it, dirt and scrape marks from where Mr. Tenzing ended up on the ground. They took his uniform pants. Those also have marks on them. They took his uniform equipment. That also has scrapes and marks on it. That's probative. That's proper evidence. They also took Mr. Tenzing's uniform shirt, which was under the carrier vest. There's nothing on that. That has, in my opinion, no probative value, but it's an exhibit. You'll have it with you. The next layer down was this T-shirt. Absolutely nothing about that T-shirt has any evidence about what happened between Sam DuBose and Ray Tenzing on July 19th. But in my opinion, the state wants to inject the race issue in this case. To further my opinion, to further bolster the correctness of my opinion, yesterday Mr. Dieters on cross-examination of Mr. Tenzing asked him, did you ever win any awards as a UC police officer? And Ray responded about some kind of award he won. And then Mr. Dieters asked him, well, how about, didn't you have the greatest arrest, or biggest arrest record for felonies and traffic violations? And Ray said, yes, I did. And then he went in and threw out some statistic about how many African Americans Ray had cited or arrested, as if that has anything to do with this case. But again, they're trying to portray Ray Tenzing as a racist. That has nothing to do with this case. This case is between what happened between Sam DuBose and Ray Tenzing. And I would submit to you, I hate to spend all this time talking about it, and I don't know if that has affected any of you, but I think it's an issue that needs to be addressed. Ladies and gentlemen, one other thing with reference to that T-shirt, you know, if that has any value, why didn't they take his underpants or his socks? They didn't take those. There wasn't any need because they had no evidentiary value. What this whole issue is with the throwing out the T-shirt and the percentage of African Americans that Ray Tenzing may have stopped or arrested, the whole deal there is a tactic that's often used by defense lawyers such as myself. When you don't have a good case, you create a smokescreen to try to divert attention from what the real issue in the case is. And that, ladies and gentlemen, is exactly what the state of Ohio has attempted to do in this case. They know that they've got problems with their case, and they want to try to divert your attention to some other non-issue and make it an issue. Now let's talk about what we're really here to talk about. One of the things that I did yesterday to try to show you what kind of man Ray Tenzing is I showed you what kind of police officer he is. I showed you the 3 body camera videos from his stops he was involved in before his encounter with Sam DuBose. Those videos, and I apologize because they were, the first one especially was I think about 35 minutes long, and it was kind of boring. But there were several things in there that I thought were important and I wanted you to see. First of all, I think every one of the videos showed that Ray Tenzing was always polite, courteous, even-tempered, even nice to the people he stopped. Remember in that first video, one of the things you saw in there was he handcuffed the driver while he was in the car before he got him out, which is what he testified he was going to do with Sam DuBose had he had that opportunity. But the other thing that Ray Tenzing did when he got that first driver out of the car after he handcuffed him, and the sound quality was terrible in here yesterday. I couldn't understand most of it, but you'll have it back there in the jury room if you would like an opportunity to play it again. One of the things that the driver said was the handcuffs were somehow uncomfortable. Ray Tenzing immediately corrected and repositioned the handcuffs once he got him out of the car. He also placed the individual in the back of his cruiser, and he said, I'll turn the air conditioning on for you in a minute. And then he got out and he went up to the car itself, gave the keys back to the man's wife with the 4 kids in the back seat, and allowed her to, he told her, here are the keys, turn the car on, it's hot out here, have the air conditioning on for the kids. That's the kind of cop Ray Tenzing is. In that particular stop, you know that the man he had 5 open warrants, that is 5 different cases where he failed to appear in court. He was also under suspension himself, and his wife didn't have a valid driver's license. Ray Tenzing could have arrested that individual and hauled him down here to the Justice Center behind you. He could have towed that car. What did he do? He recited the individual. He just merely wrote him another ticket and said, here's your court date, go take care of those. And by the way, if you can get somebody here in 20 minutes or so with a valid license, call them and I'm not going to tow your car. That's exactly what happened. The next little short video, which was less than 4 minutes, I believe, was the stop that he made in Bellevue Park. Again, he stopped the car just like Sam DuBose's car. Registered to somebody under suspension, no front license plate. The front license plate was on the dashboard. That's not where it goes. Ray made the traffic stop. The lady driving the car, the girl driving the car, produced a valid driver's license. The individual who was with her also produced a license. Ray went back to his cruiser, ran those licenses on his computer in his car, found that neither one of them had any warrants. They were valid to go. The car was registered, in fact, to somebody else other than the girl driving it, who was, in fact, under suspension. But Ray took no action. He said, he gave their licenses back, said, you're good to go. He said, have a good evening. And I don't know if you could hear it when we played it yesterday, but the girl driving the car said, you too, officer, when Ray told the people to have a good evening. That is exactly, there are two examples, ladies and gentlemen, just within 2 hours before his encounter with Sam DuBose that show exactly how the encounter with Sam DuBose could have or should have ended. Unfortunately, it didn't. And I'll back up a little bit. The encounter with Sam DuBose would not have ended with Ray Tenzing giving him a ticket or sending him on his way, because had Sam DuBose given him an opportunity, Ray Tenzing would have discovered at the very least that Sam DuBose was carrying a load of marijuana and some cash in that car, and he probably would have ended up down here at the Justice Center. And that's among other things that Ray Tenzing might have discovered had Sam DuBose given him an opportunity. And I would suggest to you that that's why Sam DuBose was so hell-bent on getting away from the scene of this traffic stop. Ladies and gentlemen, again, I ask you to decide this case solely upon what happened between Sam DuBose and Ray Tenzing. And like with Mr. Piepmeyer, and like I did in our voir dire, if I've done anything that offended you, or Ms. Callender's done anything that offends you or upset you, hold that against us, not against Ray Tenzing. Now, let's move on to the real issue. Is Ray Tenzing guilty of murder? Is he guilty of voluntary manslaughter? Those are the two charges that are contained in this indictment that was filed by the state of Ohio. And as we talked about on voir dire, or on opening, I guess on voir dire, this indictment merely notifies Ray Tenzing he's been charged. It serves no other purpose. Our defense has been throughout that Ray Tenzing was justified in what he did. That is, he's not guilty of murder, he's not guilty of voluntary manslaughter. There's no question he caused the death of Samuel DuBose. But our position is that he was justified. Judge Shanahan is going to tell you, once I sit down, and once Mr. Dieters or whoever does the closing portion of the state's argument sits down, she's going to tell you the law that applies to all of this. And she's going to tell you the law with reference to murder. And she's going to tell you that you have to be, and with reference to voluntary manslaughter. And she's going to tell you that in order to return a verdict of guilty of either one of those charges, you must be convinced of the truth of the charge beyond a reasonable doubt. She's going to tell you the burden is on the state of Ohio to prove the guilt of Ray Tenzing beyond a reasonable doubt. And she's going to define that for you. And she's going to read the definition that the state of Ohio, the legislature of the state of Ohio, has done with reasonable doubt, what they say it is. Ladies and gentlemen, that statute, as we discussed, is read, or that definition of reasonable doubt is read in every criminal case that is tried in every courtroom in the state of Ohio. It's read verbatim to the jury. And I would urge you to pay close and careful attention to that, because that's what controls and overshadows your entire series of deliberations here. As I said, there's absolutely no dispute that Ray Tenzing shot Sam DuBose, and that shot ended in the death of Sam DuBose. Murder, judge is going to tell you, is the purposeful killing of another. And I think that Mr. Pietmeyer told you a little bit about the definition of murder, of purpose. And you're going to hear from Judge Shanahan as she reads through her charge a longer definition of purpose than what Mr. Pietmeyer told you, but it's going to start out like this. A person acts purposely when it is his specific intention to cause a certain result. It must be established in the case that at the time in question there was present in the mind of the defendant a specific intention to cause the death of another. You've heard the testimony here, ladies and gentlemen. Ray Tenzing told you, I didn't shoot Sam DuBose to kill him. I shot him because he was threatening my life. I thought my life was in danger or I was going to suffer serious bodily harm. I shot him to stop that threat. And ladies and gentlemen, if you find that that is in fact, that Ray Tenzing fired that shot to stop a specific threat to his life and he was justified, then your verdict must be not guilty of murder. Now the next charge you're going to be asked to consider, if you find him not guilty of murder, is that of voluntary manslaughter. And voluntary manslaughter requires that the defendant, that is Ray Tenzing, have fired that shot knowingly. It requires he knowingly caused the death of Sam DuBose while Ray Tenzing was under the influence of sudden passion or in a sudden fit of rage, either of which was brought on by serious provocation occasioned by the victim that was reasonably sufficient to incite Ray Tenzing into using deadly force. Well, let's look at this, ladies and gentlemen. Is there any evidence at all that has been presented to show that Ray Tenzing was under the sudden influence of... Is there any evidence at all, ladies and gentlemen, that shows that Ray Tenzing was under the influence of sudden passion or in a sudden fit of rage? Absolutely none. Ray Tenzing was under the influence of a sudden fear of death or bodily harm. He was in sheer terror. He wasn't, and basically what that means is, was he angry? Was he upset? He wasn't angry or upset with Sam DuBose. He was scared to death. That's why he fired his weapon. And by the way, as an aside, there was some issue. I mean, some of you may be wondering, well, why did he have to fire his gun? Couldn't he fire a taser? And you know the evidence is that UC police officers are not equipped with tasers. And that relates back to something that happened years ago at the University of Cincinnati. Their officers don't carry tasers. I think the evidence was that he had chemical spray and a baton besides his gun. No way that he could get a chemical spray or a baton out, and no way that that's going to stop Sam DuBose, who Mr. Pietmeyer says was not armed with a gun or with a knife. But I would submit to you that the evidence is very clear that an automobile can be just as deadly as a gun or a knife. And in this case, Sam DuBose was using his car as a deadly weapon. Ladies and gentlemen, the definition of under the influence of sudden passion and in a sudden fit of rage will be read to you also by Judge Shanahan. And that'll be, and you're going to have, I'm looking here, I'm reading from her charge that she's going to read to you in a few minutes, and you'll have that with you back in the jury room, so you can refer to it also. But it says under the influence of sudden passion or in a sudden fit of rage means there is serious provocation occasioned by the victim that is reasonably sufficient to incite a person into using deadly force. It is an act done in the heat of blood without time to reflect or for passions to cool. For provocation to be reasonably sufficient to bring on sudden passion or a sudden fit of rage, you must decide that the provocation was sufficient to arouse the passions of an ordinary person beyond the power of his or her control. When deciding whether the defendant was actually under the influence of sudden passion or in a sudden fit of rage, you must consider the emotional and mental state of the defendant and the conditions and circumstances that surrounded him at the time of the act. Ladies and gentlemen, what that says is that Ray Tenzing, in order to find that he was under a sudden fit of passion or rage or whatever, he had to be mad at Sam DuBose. That's not the case here. And if you find that that doesn't apply, then voluntary manslaughter is not something that you can consider. It's simply not applicable in this case. Now, Ray Tenzing maintains that he was justified in using the deadly force to protect himself because he feared for his own safety, his life, or for feared bodily harm from a deadly weapon, an automobile that Sam DuBose was operating. Judge Shanahan's going to provide you with the law, again, in this charge that she's going to give you about justification. And I want to read to you, because Mr. Pietmeyer referred to it, and I want to read again to you exactly what she's going to say. She's going to tell you the standard of law to be applied in determining whether the use of deadly force by a police officer is justified is as follows. Deadly force may be used if the officer reasonably believes that such force is necessary to defend himself from the actual use of or imminent use of physical force by the suspect that poses the threat of death or serious physical harm. If such circumstances exist, then the officer's use of deadly force is not unreasonable. The test of reasonableness requires careful attention to the facts and circumstances, including, but not limited to, the severity of the crime that the defendant police officer was addressing, whether Samuel DuBose posed an immediate threat to the safety of the defendant police officer or others, whether Samuel DuBose was actively resisting or attempting to evade arrest by flight, whether the defendant police officer played a role in creating the dangerous situation. Those are all factors she's going to tell you to look at to decide whether this was a justifiable use of force. And she's going to go on and tell you that the reasonableness of a particular use of force, and this is to me the most critical part of what she's going to tell you, must be judged from the perspective of a reasonable officer on the scene rather than with 20/20 vision of hindsight. The determination of reasonableness must allow for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force to be necessary in a particular situation. The test of reasonableness is not capable of precise definition or mechanical application. The reasonableness inquiry is an objective one. The question is whether an officer's actions were objectively reasonable in light of all the facts and circumstances confronting him without regard to his underlying intent or motivation. That, ladies and gentlemen, is the law that the judge is going to tell you that you should apply to this case. And I would suggest to you that once you consider that, you will find that Ray Tenzing was a reasonable police officer, and above and beyond anything, you'll have back there with you the State's Exhibit 20, which is Grant Frederick's report, and on that there's a little clip. I played it yesterday for you, and you've seen it 3 or 4 times, but it's the actual body camera video from the seconds that this shooting lasted, and you'll see exactly how quickly this whole situation occurred. And I ask you to, and none of you are police officers, but I ask you to try to put yourselves in that position and ask yourselves, how would I react? What would I do? Was Ray Tenzing's response reasonable to being dragged? And we talked about drag. Mr. Pietmeyer says there's no evidence of Ray Tenzing having been dragged. Well, I guess that kind of depends on your definition of drag. I mean, I think a lot of people think drag means, well, you got to move from here to here. That's being dragged. Well, I would submit to you that at some point, to get from here to here, it has to start. What happened here was the very start of the dragging is what caused Ray Tenzing to draw his weapon and fire the shot that killed Sam DuBose. You'll have the body camera video, and I'm going to talk about a little bit about the testimony we've heard. But you're going to have, you heard Ray Tenzing, and you'll be able to see, I think, on the video, that Ray Tenzing the evidence is the car moved. And when that car began to move, Ray Tenzing's arm was caught in that car. And as soon as that happened, he started to lose his balance and fall. And he told you that's when he used the term dragged. Maybe the better term is I was thrown off balance and I began to fall. And I was afraid I was going to get run over by the wheels of that car. Ray used the term dragged. I think it applies, but perhaps you have a different definition. In any event, the fact that he was moved up the street by that car is what occurred here. Somehow he got up there. And to suggest that he was running alongside of the car is totally preposterous. When you see, on that video, you saw Grant Fredericks has one still photo where Ray's feet are laying on the ground right at the rear wheels of that car. He didn't run beside that car. He can't run backwards as fast as that car was moving. Again, what would a reasonable police officer have done, and what kind of split-second decision would he have made in this situation about the level of force, given what he had available to him to protect his own life in that tense, rapidly evolving situation? It's not what would a reasonable police officer who watched this video dozens of times in slow motion and frame by frame have done. It's what would a reasonable police officer in that 3 seconds that this was actually occurring have done. Let's briefly revisit what I think the evidence has shown or hasn't shown in this case. And again, what happened to Ray Tenzing is the key to determining whether he was justified. The issue is, and maybe I'm not the sharpest knife in the drawer, maybe I've missed something here, but to me the key issue in this case is, was that Honda in motion at the time that gun was fired? Because if the Honda was in motion, it's perfectly reasonable to believe that Ray Tenzing was thrown off balance and felt like he was going to get sucked under the rear wheels and run over, just as he said. The evidence as far as was the car in motion, well, we've got a bunch of witnesses that I think prove absolutely that the car was in motion. First and foremost, there were 4 people besides Sam DuBose on the scene that day. You had Ray Tenzing himself, you had police officers Philip Kidd and Joel Schmidt from the University of Cincinnati, all of whom said that the car, they heard squealing tires, the car moved and turned to the left, and then they heard the gunshot. Eyewitnesses say that the car was in motion when that gunshot was fired. Alicia Napier was there. Mr. Pete Meyer referenced her testimony. I felt sorry for Alicia because her car was parked in front of Sam DuBose's. She told you I had my I think 6-month-old child and my 3-year-old child in the car, and I was extremely concerned about their safety. I was looking in the rearview mirror at what was going on. And remember, in cross-examination, she told you that she had to look at YouTube videos to fill in the blanks from what she saw or didn't see. She was more concerned and traumatized about what was going on with her kids. And this again happened so rapidly and evolved so quickly that Alicia Napier, the only thing I think you can take from her testimony is that Sam DuBose somehow had to maneuver that car to the left with it, or else he would have run into the back of her car with her kids in it. The other evidence, ladies and gentlemen, by the way, we keep talking about this body-worn camera. You know from the testimony that camera, what you're seeing there is what that camera saw. That camera does not necessarily see what Ray Tenzing saw with his own eyes. It certainly doesn't have a brain to perceive what Ray Tenzing perceived, and it certainly doesn't have guts to perceive what Ray Tenzing was feeling in his guts. What I'm saying is that video on the camera video is one slight portion of what the evidence is in this case. You don't look exclusively at that, but even if you do, you 12 must decide what you think that shows. Who else testified about the car being in motion? Well, I would submit that Dr. Karen Lohman helped prove that car was in motion. Remember, she testified that when that brain stem of a human being is severed, all control ceases. Dr. Lohman, I've got no dispute with that, and I would suggest that once that bullet entered Sam DuBose's head, he had no further control. But what do we know before that bullet entered his head? What had to happen? Well, with his right hand, he started the car. He put it into gear. You'll see on the, I think you can see on that video, on those frame by frames, the position of the steering wheel changes. We know he had, from everybody, that he had to turn left to get away from hitting Alicia Napier's car. He mashed the accelerator. With his left hand, he grabbed hold of, or he put his left arm over the left arm of Ray Tenzing. Those were all conscious things he did, and they were all done before the shot was fired. There's no question in my mind that the car moved before that shot was fired, and Sam DuBose was in control of it and turning it to the left. And I think Dr. Lohman's testimony helps establish that. Next, we heard from Grant Fredericks. You know, Grant Fredericks seemed like a nice fellow. He's well educated, probably pretty good at what he does. He certainly sounded like he knew what he was talking about. You'll have his presentation. It's got frame by frame. He's got red circles and red arrows and so on and so forth. He broke everything down to milliseconds. I thought this is very impressive. But then I cross-examined, and Mr. Fredericks, by the way, on his direct testimony said he agreed also. The car moved. He said it moved forward no more than 2 feet. He couldn't tell us whether it had turned to the left, being the expert that he was. But he started to lose me a little bit right away when I started cross-examining him. You recall I asked, "Are you being paid for your testimony?" He said yes, and I asked him how much. And, "Well, that's not my department. I have no idea." Ladies and gentlemen, when he said that, he really started to lose credibility with me, because I don't believe you fly all the way across the country to testify in a case and not have some idea of how much money you're going to make for doing that. But beyond that, ladies and gentlemen, you'll have with you again his report, and by the way, in his written report, which is part of State's Exhibit 20, he lists every statement that Ray Tenzing made at the scene of this event at Rice and Valencia after it was all over about I was being dragged, my hand was caught, and he says in there, Ray Tenzing was lying when he said all that. I didn't hear Mr. Fredericks testify that he had any credentials that made him capable of detecting when somebody lies. And that wasn't what his function was, but it's in his report and you'll have it back there. But the one thing that where he lost me was with his slide number 2, which you'll have. Remember, I put that up there. It was, to me, a crystal clear picture before anything happened from Ray Tenzing's body camera of the Honda pulled to the curb behind Alicia Napier's car. And that Honda had, I mean, again, I'm not the video expert, neither was Jim Scanlon, but to me, and you all will have a chance to look at it, the Honda's wheels are pointed straight ahead. Indicative to me that if you are going to move that Honda and avoid Alicia Napier's car, you got to turn it to the left. I also asked him from that picture, can you determine whether the wheels are straight? He said, well, that would require me to speculate, so I can't tell you that. Then I asked him, well, how about Rice Street? Can you tell whether that is an uphill grade, a level street, or downhill? Well, I can't tell. That would require me to speculate. And yet he can look at the blurry pictures that you've got, that you'll have, that you saw the frame by frame, and he can tell you precisely what's going on there and tell you within milliseconds of what's going to happen. When he couldn't look at a picture clear as day and tell you what it depicted, I wondered how can he look at these blurry things and tell you what's going on. And you heard Jim Scanlon testify yesterday. Mr. Gibson kind of mocked him because he's not a video analyst or video expert. Jim Scanlon never claimed to be. But Jim Scanlon used those same frames to try to explain what he thought happened in this case. And his view is just as good as Grant Fredericks. His view is going to be just as good as any of the view any of you may have of what happened here. And Judge Shanahan's going to tell you that the testimony of experts is designed to assist you in your evaluation of the evidence. It's not entitled to any greater weight, any lesser weight than the testimony of any other witness. They are simply here. You judge their credibility. Ultimately, it's your decision to try to figure out what happened here. And if you can't figure it out, that's a reasonable doubt and it should result in a verdict of not guilty. Scott Hogg testified. Scott Hogg, well, he agreed with he agreed with Grant Fredericks. The car moved before the shot was fired. I'm sorry, Scott Hogue. Scott Hogue indicated that not only had the car moved, but he indicated that if an officer makes a tactical error, and I'm not going to dispute, we're not disputing, there's no question Ray Tenzing should not have reached in Sam DeBose's car. But when an officer makes a tactical error, he doesn't forfeit his right to live or his right to be free from bodily harm. He has a right to protect himself, which is what Ray Tenzing did in this case. Pardon me. You know, Ray Tenzing was 6 feet 3 inches tall, 6 feet 3 inches tall, he testified. And I'm going to drop back to Fredericks here for a minute. When he walked up to the car, you see, and you'll see in there, you see Ray Tenzing is looking down. There's a picture of the roof of the car. When this shot is fired, when Ray Tenzing said he was being dragged, look at that video and look at those still frames, and you'll see that as Jim Scanlon testified, and I think as Mark Pietmeyer just demonstrated, the body camera is pointing up, and you'll see the bottom of the roof of the car. The interior ceiling of the car is depicted. That's not from Ray Tenzing standing straight up, as Grant Fredericks wants you to believe. That's from Ray Tenzing going down and the camera pointing upwards. Scott Hughes testified. We had heard his testimony by deposition because we deposed him last Friday afternoon after you all left because he couldn't be here this week. And with the events that occurred Friday, we couldn't get to Scott to testify live. But we read his deposition. I guess it was yesterday, the day before yesterday. I've lost track of time here. But we read his deposition, and Scott Hughes testified that I teach this course, and Ray Tenzing took the course. Never, 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 never reach into a car, is what Scott Hughes said he teaches officers. Well, Scott Hughes agreed that two things. Number one, as a police officer, Scott Hughes has reached into cars. He agreed that officers do it in spite of the fact they're trained not to. Scott Hughes agreed that the OPATA manual, which every officer in the state of Ohio is trained under, indicates that if you're going to reach into a car, reach in with your non-dominant hand. It says don't reach into a car with your dominant hand. To me, that suggests that the opposite is something probably not recommended, but not absolutely forbidden. And I don't know how you could ever be a police officer and never, never reach into a car. It's just not possible. Scott Hughes agreed there are no absolutes like that in law enforcement. The other thing Scott Hughes talked about was Cincinnati police officer Kevin Crayon. Kevin Crayon was involved in an incident very similar to this, but the results were a little different for Kevin Crayon. Remember, Scott Hughes told you Kevin Crayon reached into a vehicle that was driven by a 12-year-old boy, trying to do exactly what Ray Tenzing did. He wanted to knock the keys out. As a result of that, Kevin Crayon was dragged, and Kevin Crayon died, as did the 12-year-old boy, because Kevin Crayon shot him, trying to stop the threat. Point of that is, the Kevin Crayon story is that, number one, it shows that officers do reach into cars and get dragged, and it shows that automobiles can be deadly weapons. The exact same scenario here. For Ray Tenzing, fortunately, he wasn't badly hurt. Now, I talked about Jim Scanlon for a little bit, and he's going to, you've heard what his testimony is. You saw him get up here and demonstrate what he thought was depicted in those frame-by-frame videos, and I would suggest that his testimony is just as worthy of belief as Grant Fredericks or Scott Hogue's or Scott Hughes. Jim Scanlon was an expert. He told you he's been a police officer for 33 years. He told you that after reviewing everything that he reviewed here, and he became involved in this case, he said, because he was up in Columbus reading about it and thought that the whole thing was so preposterous that he wanted to become involved in it, and he started paying attention to it and reviewing it. And after he reviewed everything, he came to the conclusion, unlike Chief Hogue from Rock Falls, Idaho, Jim Scanlon came to the conclusion that Ray Tenzing's use of deadly force was justified. And I would suggest that, again, ultimately, it's your decision, but I would ask you to carefully consider what Jim Scanlon had to say. And again, Judge Shanahan's going to tell you that the expert's testimony, just like every other witness who testified, you decide whether you believe any of it or all of it or part of it. At the end of the day, you all are the triers of facts. You make the decision on what occurred here. I would suggest to you, again, you can't use 20/20 hindsight. That's what the judge is going to tell you. Monday morning quarterback. You got to put yourself in the position of a reasonable police officer on the scene as this is occurring. You know, this whole trial has been about 20/20 hindsight and Monday morning quarterbacking. All the experts have viewed this video dozens and dozens of times, hundreds of times probably, to tell you what it shows. Ray Tenzing on July 19th, 2015, on Rice Street, didn't have the luxury to sit back and look at it frame by frame. He had to make an instant decision. And that's what brings us all here. And I think that decision was justified that Ray Tenzing made. Ask yourself, are you firmly convinced of the truth of the charges? Would you be willing to rely, and this is part of the definition of reasonable doubt that Judge Shanahan's going to tell you, would you be willing to rely and act upon the evidence that's been presented in this case in the most important of your own affairs? That's reasonable doubt. That's the definition. You know, police officers, ladies and gentlemen, are the last line of defense that we have in this country between good guys and bad guys. Ray Tenzing didn't set out on July 19th, 2015 to kill anybody, to kill Sam DuBose. We've been scrutinizing what Ray Tenzing did on this day. Nobody has paid a whole lot of attention to what Sam DuBose did. I'm not here to badmouth Sam DuBose. I feel terrible for the DuBose family, as does Ray Tenzing. But Sam DuBose had some role, major role, in what occurred on this day. You saw the two videos before Ray Tenzing's encounter with Sam DuBose. Those ended without anybody getting shot because the people complied with what the officer requested. Police officers have a sworn duty to uphold the law and provide for public safety. And that's what Ray Tenzing was doing on that day. When they are threatened, they have the right to protect themselves. And that's what Ray Tenzing was doing on that day. Nobody but the officer on the scene can tell you how they would react or what is reasonable when an incident starts to escalate. Again, as jurors, you're going to be asked to put yourselves in that position if you possibly can. But ask yourselves, would I have done anything different to protect myself if I was trapped in a car, my arm was stuck in a car, and it was starting to move? I suggest that the evidence in this case, ladies and gentlemen, doesn't even come close to proving that Ray Tenzing is guilty of either murder or voluntary manslaughter. And I would ask you to return to this room with a verdict of not guilty as to each one of those charges. Thank you.
Thank you, Mr. Matthews. Mr. Bruce? Yes. Yes. All right, ladies and gentlemen, it's 20 till 11. We're going to take a brief recess. Remember the admonition, do not discuss this case among yourselves. Do not allow anyone to discuss it with you. Do not form or express an opinion about this case until it is finally submitted to you. All rise.